Good evening to all of you. Welcome to Legal Matters by Sai Baba Sankara Torts class. In this video, we are going to discuss a very important case, landmark judgment, Darla Verma and others versus Delhi Transport Corporation 2009, where the Supreme Court held that the claims tribunal need not be rigid in following the multiplier theory because special provisions as to payment of compensation, they should be done on, no doubt, on structured formula basis, but sometimes if some permanent liability, disability comes, definitely you have to take a sympathetic view. ఆల్రెడీ ఐ టోల్డ్ యూ, ఒక కేసులో ఏదైనా యాక్సిడెంట్ అయినప్పుడు ఒక మనిషికి 30 ఏళ్ల కుర్రాడు 30 ఏళ్ల వయసు అతను చనిపోయాడు, ఉద్యోగస్తులు 1500 ఎంత వస్తాయి, దాన్ని బట్టి మల్టిప్లయర్ థియరీ ప్రకారం ఇంత అని చేస్తారు. ఆ మల్టిప్లయర్ థియరీలో కూడా టేక్ హోమ్ శాలరీ అని ఉంటుంది, అది కూడా తీసేస్తారు, పర్సనల్ ఎక్స్పెన్సెస్ తీసేస్తారు. కొన్ని సందర్భాల్లో ఈ లెక్కలన్నీ అక్కర్లేదు, అవతల మనిషికి దెబ్బ తగిలితే ఈ హ్యాస్ టు బి కాంపన్సేటెడ్ హెవీలీ అని చెప్పడమే సరళా వర్మ కేసు యొక్క ఉద్దేశం. Very important case. So now coming to the facts of the case. Please remember section 163A of the Motor Vehicle Act. So please remember, it clearly says that the claims tribunal need not follow the multiplier theory. Right? So this is an important case. Right. Coming to the facts of the case. The complainant or the plaintiff, Mr. Rajendra Prasad, aged about 35 years. So he received injuries, ultimately he died. We can call him as deceased. He died of the injuries occurred on 18/4/1998, in which a bus of Delhi Transport Corporation was injured. That means the driver of the DTC bus drove it in a rash or negligent manner and caused the accident, due to which Rajendra Prasad received injuries and ultimately he died on 18/4/1998. Right. This Rajendra Prasad, at that particular point of time, at the time of accident, he was working as a scientist in ICAR, Indian Council of Agriculture Research. So his monthly salary was 3,402 rupees. By the time he was survived by a widow and 3 minor children. So that means his mother was there, his wife and 3 minor children were there. Right? He filed a claim for 16 lakhs rupees. Because of the accident, he has suffered so many injuries. Ultimately, he filed a claim for 16 lakhs. But the tribunal awarded compensation by taking the multiplier theory. That is, monthly salary 3,402 and deduction of expenses maybe 1,000. This is the 2,250 after deducting of personal expenses. So they have calculated his salary as 2,250 and multiplier theory ultimately 5.94 lakhs actually. Athan vesin 16 lakhs ki. Right. So 5.94 is the I have claimed for 16 lakhs. What is this 6 lakhs? And he appealed to the High Court. So the High Court arrived at 7.02 lakhs. Now 7.20 economy. Now the insurance company, they have appealed to the Supreme Court. So please remember, no doubt, the Supreme Court said, we agree that the deduction on the personal expenses and living expenses cannot be standard 1/3. Normally 1/3. Already I told you, when the salary is 3,402, the personal expenses were around 1,000 rupees. That is what we call as take-home salary or personal expenses. So this cannot be standardized to 1/3. Some people may have extra expenses. Here he has to maintain his wife, 3 children, father, mother and so many persons. So therefore, this is not the standard 1/3 and the court held it as 1/8. So ultimately, the loss of dependency, they determined compensation at 8.64 lakhs. That means almost 50% of his claim has come. So please remember, here the important point is, normally you have to follow the multiplier theory. But in important cases, you need not do so. That means just the same word I have been telling you. Every case depends on the facts and circumstances. So you can't have a fixed or rigid frame. No doubt, multiplier theory can be followed in various stages. But when the person is survived by so many persons and so many persons are dependent on him, definitely this theory may not be applicable and the court can award more compensation. Therefore, the 8 lakhs compensation was granted. Right? This is a famous case that is called as Darla Verma and others versus Delhi DTC, Delhi Transport Corporation 2009. So this is a very important case law. Even though you do not get it in the examination, this will be useful for you at the time of practice. That's what I want to tell you. Thank you.